Hello, everyone, and welcome to Speech Here. And I'm here today with Charles B. Ticker, mediator and estate litigator. And we're going to be discussing the 7 biggest mistakes that lawyers make attending a mediation, preparing for a mediation with respect to mediation. So, Charles, what would you say is the first mistake that lawyers make with respect to mediation?
Well, number one, and this is like anything that lawyers need to do, they're not prepared for the mediation. They haven't reviewed the file, they haven't reviewed the facts, they haven't even reviewed the history of the matter. So they come to the mediation and are taking positions that have no relation to the file. So lack of preparation on the part of counsel.
Does that really happen?
It does happen, particularly where you have counsel, sometimes senior counsel, no offense to senior counsel, relying on an associate who's probably more familiar with the file, and the senior counsel has just been so busy and hasn't really, reviewed the file properly before the mediation. So yeah, or they haven't kept up to date on the law and are taking a position that doesn't jive with the recent case law. So I've seen that happen.
So they come and they think I'm experienced, so I'm going to wing it.
Well, it's like anything else. You have to be prepared. You can't wing it.
Okay. All right. What would you say is the second one of the biggest mistakes that lawyers make with respect to mediation?
Not preparing the client for the mediation. The client, for them, it's probably going to be the first time they're at a mediation. They don't know what to expect. They think it's like court. So the lawyer has to explain to them that mediation is not court. It's not a decision-making process by a third party. It has to explain the role of the mediator as a neutral, there to facilitate discussions, and that it's really the client's stay to try and make a settlement with the other side. And also to manage the client's expectations. I see so many mediations go off the rails because both sides would take really unreasonable positions and are not prepared to compromise. So the clients have to be prepared by their counsel that they must be prepared to make serious compromise, or the mediation is not going to be successful.
And would the lawyers also prepare their clients about, whether they're going to be in the same room as the opposing party or not?
Yes, obviously you want to explain to the client that there would be an opening joint session, and then they'll be breaking out into separate rooms. And now on Zoom, we do all this virtually. A lot of clients aren't comfortable with being in the same room with their, let's say, their sibling, even if it's virtual. So the way I usually get around that as a mediator is to say, well, just turn your video off and they don't have to see you. But I think it's important to have those opening joint sessions to explain the process, and so everybody understands that mediation can work if everybody is serious about making compromise.
Okay, so the first mistake you said was lack of preparation of the lawyers themselves, coming not prepared to the mediation. And the second mistake that you said is lack of preparing the clients, and you made a good point about not preparing them in terms of being willing to settle. So what would you say is the next of the biggest mistakes? And I assume these aren't in any particular order, am I right?
Yes, they're not in any particular order.
Okay. So what would you say is the third of the biggest mistakes that lawyers make with respect to mediation?
Well, I've talked about this in another video about, how long should the mediation brief be? So I think one of the mistakes that I've seen counsel make is not making proper use of the mediation brief, making it way too long, throwing in all kinds of information that's really not material, or maybe making it too short so the mediator is sort of guessing as to what's going on in the file. And it's difficult, for counsel to maybe distill everything into a shorter brief, but it is helpful to the mediator in getting a sense of what the issues are. So I think counsel have to pay more attention to the preparation of the brief and also timely delivery of the brief. If the mediator says they want the brief, 7 days before the mediation or 5 days before the mediation, don't expect the mediator to be able to read and absorb it if you give it to the mediator the night before the mediation.
Yeah, 200 pages the night before, and then it's it to be absorbed. Okay, so that was the third mistake, not paying enough attention to the length of the brief and the timely delivery of the brief. And as you said, you have another video on how brief should the brief be. Okay, that brings us to the fourth mistake that lawyers make with respect to mediation. What would that be, Charlie?
Not having the decision makers, the necessary persons there who have the authority to make the decisions on settlement at the table. You may be missing a key player that needs to be there to make sure that the settlement is effective. And if they're not going to be at the hearing or at the Zoom meeting, make sure they're available by telephone or email so you can get instructions. So I've seen that happen where the mediation has to be adjourned and the settlement can't be finalized because the person with authority is not at the table.
That actually happens, Charles?
Yes, I have seen it happen. I have seen it happen, yes.
All right. Okay, so not having people with proper authority, proper decision makers at the mediation or available by phone. So that was the fourth mistake, I believe. What would be the fifth of the biggest mistakes that lawyers make with respect to mediation?
Not having minutes of settlement signed. Parties are there, for 8-9 hours, and they think, oh, we have a handshake, and but they don't get anything down in writing because they say it's late or it's we'll do it tomorrow. Don't leave that mediation until every party has signed, if not a formal minutes of settlement, at least a settlement outline which sets out the key points. So you have something that is to document the settlement and something that maybe can be enforced by a court if the settlement is breached. And as an aside to that, make sure nobody leaves the mediation until everybody has signed. I had a mediation once where one party signed, they thought they were done, so they left the building. Well, the other side came back and said, well, we have one other little point, but they wouldn't sign until that little point was dealt with. And we couldn't find the party had left the building. So the whole thing fell apart. So sign minutes of settlement and make sure nobody leaves or turns off their video until it's confirmed that everybody has signed minutes of settlement.
All right, that's a good one. Lock them in until everyone has signed minutes of settlement. Number 5. All right, we're moving right along to number 6 here. What is the sixth of the biggest mistakes that lawyers make with respect to mediation?
Underestimating the amount of time that's required to conduct the mediation. Quite often, lawyers will call me up and say, well, I think we only need a couple hours or a half day. We don't need a full day. And I always say to them, by the time I do my opening remarks, you have a coffee, you say good morning, you're already well into the morning. And it, like anything else, mediations tend to start slowly and then pick up steam as the day progresses in terms of settlement offers and negotiations. So, and quite often mediations will go beyond 5 o'clock. The parties are still negotiating, but they're not quite there yet. And they could go well into the evening or even sometimes the late evening or early hours of the morning, although that's rare. So make sure that both the lawyers and the clients don't have anything planned, and the mediator don't have anything planned, for that evening, because it may go into overtime. So clients don't realize that. They think
not a 5:30 family dinner and a night out at the opera.
Right. I mean, maybe take a short break for dinner, but don't have tickets to the opera or to the hockey game because you may be needed to continue the mediation. So that's a mistake that I've seen made.
All right, number 6, not booking enough time for the mediation, and that brings us to number 7, the last of the biggest mistakes that lawyers make with respect to mediation. What would that be, Charles?
Choosing the wrong style of mediator for your case. And there's a lot of debate about this because someone a lot of people argue that a mediator who's good can mediate any case. And that may be true, but having said that, as counsel, I have seen mediations go off the rails because a mediator has been too evaluative, too aggressive, too early, and has turned off the parties. So they don't want to, they get their backs up, they don't want to talk. They've lost trust in the mediator, they've lost trust in the system. This could be a mediation video by itself, and I think, stay tuned. Another video will be coming. Do you need a specialist in the area of law that you're disputing, or can a journalist do as good a job? Should you have a judge? Should you have a lawyer? Can you have a non-legal person? These are all good questions, but I think consideration has to be given to which mediator may be the best fit for your case. And as counsel, when I'm choosing a mediator, sometimes I'm looking for a mediator who's had experience in that area of the dispute, and because that will speed things up, because the mediator has expertise in the area, and it will take less time to explain the issues and the law. Like I said, there's a big debate about this, but I've heard counsel say they want to get evaluative mediators because the clients need to be told, how it is, and you should get a retired judge or something like that who's going to basically someone that they're going to listen to. That can work. It can backfire, but I guess the point I'm trying to make is it's not just picking someone from a list. Some consideration has to be given as to whether or not that mediator is a good fit for that case. You can't do that in court, but you might be able to do that in a mediation.
Thank you very much, Charles. And I hope, I imagine you'll be explaining to us in your subsequent video what evaluative mediator means. We'll look forward to that video when it comes. So number 7, not hiring the right mediator to begin with. Today, we have had as our guest Charles B. Ticker, mediator and estate litigator, with the 7 biggest mistakes that lawyers make with respect to mediations. Charles, thank you very much.
My pleasure.